Welcome to Who Wrote That Up For You, a daily podcast that shines a light on the American justice system and its role in empowering the powerful to take from you. The justice system is the only branch of your government where an individual, rather than the collective, can make the system act for you. It puts power in the individual's hands, but it's broken and being used against you at a time when you need it most.
And welcome to Who Wrote That Up For You. I am Sonia Ebron, co-founder at Courtroom 5.
And I am Deborah Sloan, the other co-founder at Courtroom 5.
Fantastic show lined up for you today. In a few moments, we will speak with Scott Dodson. He is the Distinguished Professor of Law at UC, that's the University of California, Law in San Francisco. He is the director there of the Center for Litigation and the Courts. Just a broad expert in civil procedure and the federal courts. And so we're excited to talk with him about the complexity of some of these rules of procedure, why it's difficult sometimes for regular people to access them. But he's going to take us to school for sure on civil procedure. So looking forward to that conversation. Before we get there, though, Deborah, what is on your mind today?
I want to talk about qualitative immunity, but I also want to kind of put that in the same context as litigation privilege. So qualified immunity is it's a type of legal immunity that cops have, most primarily cops who can use that immunity to basically defend themselves against what looks like a violation of someone's rights. And so I pointing to a case where an Austin, Texas police officer killed a fellow named Michael Ramos in 2020, and he's just been basically the court determined that he didn't have qualified immunity. The reason why I bring it up now in the context of litigation privilege is it's a lot the same thing, except it's a more it's not a gun thing, but but litigation privilege is basically the same thing where you can pretty much do any darn thing to in defense of your client if you're an attorney. And I've been on the opposite side of this, so I've seen it in action. That you have a litigation privilege if you're an attorney, and there's a whole lot you can do, a whole lot that you can get away with, especially if it's against a pro se litigant.
Absolutely. That is actually that is so funny, and I know we could spend a lot of time on litigation privilege here and the similarities. That's a interesting parallel you would draw to qualified immunity. There, I'll just say that. But I understand.
I
I
think it's
understand.
very similar.
I'm not going to argue with you. That is funny. Well, at Courtroom 5, we believe the courts belong to the people, in particular to the people who use them. And we, the people, are coming to claim our courts. So if you are in court without a lawyer, or you need to sue someone and can't find a lawyer to represent you, get yourself over to courtroom5.com. Try a limited version of our services for free, and we hope to provide some relief for you there. At this time, it's my pleasure to welcome onto the show Professor Scott Dodson at the University of California Law in San Francisco. Professor, thank you so much for joining us on Who Wrote That Up For You.
It's great to be here. Thanks for having me.
Fantastic. And so, Scott, if I may, give us your background. What brought you to the practice of law, to the education of law?
Yeah, well, I really love being in the classroom in front of the students, communicating the knowledge that they'll need to be successful lawyers out in private practice or public service, whichever they choose. And I really love the research and writing aspect of my job. I've published a number of pieces, and they've been cited by courts, and I'm hoping to change the law using my writings.
Fantastic. Change the law. Let's dive into it then. I know that you're a widely recognized expert in civil procedure, in particular expertise in the federal courts. Tell us, let's just dive way back. Why do we have a civil justice system? What's the value of that in a democratic society or any society?
Right. So the civil justice system is distinguished from the criminal justice system, which is when people or entities who commit crimes are prosecuted, and if they're found guilty, they're fined or imprisoned. But the civil justice system is really for private dispute resolution. So you can think of car accidents or a breach of contract or workplace discrimination. Those are civil actions that can be the basis of a lawsuit, where the remedy is usually money that's awarded as compensation for the harm. So the reason why we have a civil justice system is basically to resolve private disputes and to provide compensation for unlawful harms. But it has some other ancillary goals and effects. So one is the deterrence of future harm. So if you know that you can be held liable in a civil lawsuit for a car accident if you're at fault, maybe resulting in you having to pay for the harms that you've caused, or at least having to pay higher insurance rates, you might be more careful on the highways. And that deterrence is really important in our governmental structure because it takes away some of the regulatory burdens from the government, resulting in less government. Yes, we have governmental regulation, but we actually have a lot less than in other countries. And the reason is that we offload some of that to private plaintiffs in the civil justice system. For example, race discrimination in employment is unlawful. In France, such discrimination is a crime, and non-discrimination is enforced by the government. So the government has to watch for instances of discrimination and then have the resources to be able to prosecute it. But in the United States, race discrimination isn't a crime. It is a civil lawsuit that can result in money damages. So victims of race discrimination can sue for compensation, and their successes can then deter future incidents of discrimination. Another virtue of the civil justice system is that litigation requires disclosure of evidence, and those disclosures can reveal information that has wide public interest. So, for example, if a drug manufacturer is sued for manufacturing a harmful compound, and that manufacturer actually conducted some studies that showed that harm, then litigation can force the manufacturer to reveal those studies to the public, which will then be better educated about the risks of that drug. So our civil justice system serves a number of different values and benefits.
That's extraordinary. I thank you very much for that. I mean, I can imagine the amount of money your students have to pay to get this, and you've given it to us for free in just a few minutes. That's really some crucial points there about the benefits of a civil justice system. So, if I understood you correctly, we have smaller government because than countries where these torts or these harms might be treated in the criminal justice system. And we can dissuade people or deter people, I think is your term, from creating these harms because, number one, they might have discovery that shows a number of other harms and makes them liable. A lot to unpack there. Let me just move though to asking about the cost of those. We invest a lot, right, as individuals, right? When we have a civil justice system that handles some of these harms as opposed to a government-funded criminal justice system, right, that can handle those harms. We as private citizens have to invest a lot to get justice in this system. Is it worth it? I mean, what is the value? What is the trade-off there, right, for us as citizens? And is it as effective as treating some of these harms in the criminal system?
Right. Our system does have costs. Litigation can be expensive for plaintiffs who are harmed, so that even if they win, they will actually take home less than what would be full compensation because they have to pay for an attorney and pay court costs and discovery costs. It's also difficult and stigmatizing in many instances to be a plaintiff, right? Think about trying to sue your doctor or your employer, someone you have an ongoing relationship with. And some studies indicate that a significant majority of meritorious claims are never filed. Defendants have costs too. Innocent defendants have to spend money to defend themselves just to show that they aren't liable. So the costs to the parties for civil litigation can be quite high. Also, by offloading public regulation to private plaintiffs, there's less democratic accountability in how that regulation is being forced. If you don't like the way your mayor is keeping the streets safe, then you can write a letter or lobby for different policies or vote in a new mayor who will, but voters don't control plaintiffs. So there are costs and there is less democratic accountability in the system that we've designed. But overall, in my view, the benefits outweigh the costs. We have an extraordinarily talented bench of judges and bar of lawyers. We have some of the lightest governmental regulation and lowest taxes in the world. We could do better and we could do it cheaper, but our system works pretty well for us.
Absolutely. I have no doubt about that at all. The other cost, though, or relative to the cost, there are a lot of people who can't afford to participate in the way it was designed, right? We have a huge access to justice crisis as a result, where people can't afford an attorney on some of these more complex cases, and their claims might not be addressed at all as a result. Others who are on the defense side may not be able to put up an adequate defense and may be found liable where maybe they were, maybe they weren't, right? Because they aren't able to participate in the way it was designed for financial reasons. And so why is the system so complicated, right? Why can't the average person access this basic organ of government, the way wealthier people can?
Yeah, one of the unique features of our civil litigation system is that a plaintiff can sue pretty much anyone. It's the great equalizer in our society. I can sue Apple, and Apple has to answer me. I could even sue the president of the United States. And I may not get very far, but at some point, the president actually has to answer me and show up in court and move to dismiss my lawsuit. I can force a response. And that's something that's quite unique and quite special about our system. Now, as you say, we do have costs to less advantaged litigants, and that does create some problems with access to justice. It can be expensive, it can be complicated to sue, and people can get tripped up if they don't have a lawyer. I'll tell you that when the system was designed and the rules were promulgated in the 1930s, they were actually designed to enable a plaintiff to be able to litigate without a lawyer. We have actually quite liberal standards when it comes to pleading cases. Most other countries require quite a bit more detail and quite a bit more rigor in pleadings. You can't even get into court without some lawyer to help you. Our system was designed to make it easy, and to make it easy even for plaintiffs that didn't have lawyers. It has become more complicated over the years. And I think there are a couple of reasons for that. One is that we've seen the rise of the big law firm, and the big law firm that caters to large corporations. And those corporations that are represented by those large law firms have tended to make litigation more expensive, make discovery more expensive. It's redounded to their detriment. They're the ones that end up complaining about discovery costs quite a bit. But when you have a well-heeled defendant and well-heeled lawyers, they're going to want to do whatever it takes to try to win the lawsuit. And that ends up making litigation more expensive for everyone. Now, There are some ways to alleviate those downsides. There's class actions, which can make litigation much cheaper for the ordinary plaintiff. Like, say your cell phone provider is charging you a fee every month that is just wrong or unlawful, but it's only $5 a month. Well, that's just not going to be worth litigating over on an individual basis. You'd pay way more in attorney's fees than you could ever hope to recover. And yet the cell phone company is making millions and millions of dollars off of it over all of its customers. But there could be a class action in which all of the plaintiffs band together and litigate on behalf of each other. And that could make it more effective and efficient for those plaintiffs to be able to get relief. There's also pro bono attorneys, including attorneys at firms that will represent individuals for free. And there are public interest organizations that can help offer legal services to plaintiffs that can't afford it, or for whom the lawsuit just wouldn't be economically viable. But again, as you say, there are still some people who fall through the cracks. We could do better.
Absolutely. I mean, I'm thinking about the small claims or magistrate courts versus the courts of record, as they're called. Where these rules of procedure really apply or are somewhat more enforced. And the average person, I think, can figure out how to navigate a small claims case. But if you want to sue Apple for anything above a $5, cell phone service, you're going to have to do that in real court, where the rules can get in the way of the average person. I mean, you really, you almost do need an attorney. The average person does, to be able just to file a complaint that won't be ignored or kicked out of court, right? It's a practical matter. If I didn't know anything about courts, and there was a time not too long ago when that was the case, and I tried to sue, if I had tried to sue Apple, I wouldn't have known anything about, okay, I've got to allege certain facts to meet the elements and all of this. And, if Apple had completely ignored it, what would I do? I wouldn't know anything about a default judgment or, right, trying to move that case towards where I could actually get an award, an order from the court ordering Apple to do something. I mean, there's just some things you have to know and know how to do that lawyers go to school for, right? And if I can't access one of these legal experts, I don't really have access to that system. Is there a vision where outside of the small claims context, the average person can get through and get some justice in real court?
Well, I think you'll find that there are many plaintiffs' attorneys out there that will take cases on what's called contingency fee. And that means that the plaintiff won't have to pay any attorney's fees or cost the lawsuit unless the plaintiff wins. Now, that can be a risky proposition for the plaintiff's attorney. So the plaintiff attorney might do some initial screening of the case to make a business decision of whether or not the case is worth pursuing. But there are quite a few plaintiffs' attorneys out there that will take cases on contingency to try to make it economically viable for plaintiffs to be able to find attorneys to pursue their claims for them. Absent that, we don't really have a good system for having to make it cheap and effective and easy for plaintiffs to be able to sue. I will just add that in many other systems, there's a loser pays rule in which the loser has to pay the winner's attorney's fees and costs. And that is a way to make valid, meritorious lawsuits economically viable, even very small ones. The downside is that if you lose, then it could make your very small lawsuit very expensive for you.
Yeah, yeah, no doubt, absolutely. What is the rationale? Let me just put it plainly, for the complexity of the rules, to where you do need a lawyer to be able to navigate some of these more serious claims?
I think the main reason why our rules have gotten particularly complicated is that they try to do everything for every case. So we have a system of mostly generalist courts. The federal courts can hear a case that's only worth $1, and they can hear a case that's worth $1 billion. And the same procedures and rules apply to both cases, both kinds of cases. Doesn't matter if it's a tort case or a discrimination case or an environmental case or an antitrust case. We have the same rules that apply regardless of the kind of case. And as a result, the courts have really tried to interpret those rules in ways that allow those rules to be able to apply to all of those cases in sensible ways. And that's made things quite complicated in itself. If we had a small claims court in federal court, or at least a small claims procedure, set of procedural rules to adjudicate cases cheaply and quickly, then that might be beneficial for everyone involved. But we don't. We have a general system of rules that applies and it tries to apply to all kinds of cases. And in some instances, it just makes things more complicated.
Yeah. No way around it. That's for sure. Scott, I'm going to share your faculty profile for folks who want to reach you there at UC Law, San Francisco. Thank you for the education. This has been highly valuable, certainly for me and our viewers. Thank you again for sharing your knowledge and for your expertise on civil procedure. Wish you the best of luck. We'd like to have you on again soon.
Thanks. It was a real pleasure.
Thank you.
You bet.
All right.
Yeah, there is no way around the complexity of these courts. That's for sure. I'm glad that we have folks who can at least explain the necessity for the system that we have, which is lots of folks complain about the courts, but as Scott indicated, there are some trade-offs here in terms of the type of government we get to have here, the regulations and so forth. And so there's certainly some benefit to not having to rely on the government and on the criminal law for some of the claims and injuries that we have. I get it. I get it. I do continue to pray for simplification, but of course that would put us out of business at Courtroom 5 if it were. So there's trade-offs everywhere, aren't there?
Exactly.
At any rate.
Exactly.
So, Deborah, who won the, not who won, what's the answer to the last quiz and what do you have teed up next?
All right. The last question was, which of the following is the most accurate statement about interlocutory appeals? And the answer is B. An interlocutory appeal is an appeal of a non-final order. Today's question. Tory was sued by Big Bad Bank for failing to pay a credit card debt. Before Tory could respond with an answer on affirmative defenses, the bank sent her request for admissions. Tory thought it was too soon for this type of discovery and did not feel compelled to respond. Is not responding wise on her part? That's the question. Is not responding wise on her part for this particular document? All right.
That looks like fun. And so it looks like you're looking for a yes or no on that. But I will be interested to hear your thoughts further. All right. Well, that's all we have for you today. Thanks as always for joining us on Who Wrote That Up For You? And we will see you next time.
Are you feeling beleaguered, angry, or afraid, as if things are spinning out of control and you're powerless to stop them? It's easy to just let things slide and hope they don't get worse. But they often do get worse. The thing is, you're not powerless. Our courts belong to us, and their purpose is to give power to the powerless. Don't let your grievances pile up without redressing them. You can handle this in court, or if someone takes you to court, you can take them to school.